Hello, and thanks for choosing to tune into my presentation. Today I will be introducing you to a few fierce contemporary Indigenous Canadian lawyers. These individual features will then be followed by an exploration into what the existence of these lawyers can tell us about the Canadian legal system. The progression of our discussion will be as follows. Feel free to hit pause and give our agenda a read. Here is an aerial photo of Kingston. I include this because, before comprehensively delving into this exploration, I would like to recognize that I am extremely privileged to conduct this work on the stolen land of the Anishinaabe and Haudenosaunee peoples. Through this work specifically, and an engagement with contemporary indigeneity in Canada more generally, I hope to express my genuine gratitude for my unlimited access to this space. Generally, it is imperative to look to the history preceding a social phenomenon in order to contextualize its contemporary existence. In our recent history, the Canadian legal system treated Indigenous peoples as less than the dominant settler population. The Canadian government used the presumed legitimacy of the law to make personal gains that subsequently resulted in major disadvantages for the Indigenous population. This can be exemplified through the legally condoned treaty-making process, which coerced the procurement of traditional Indigenous lands and resources. Additionally, it is important to recognize that the current legal system is inextricably bound to its historical roots. This system was created by colonial institutions who were empowered by racist attitudes. For example, until 1951, the Indian Act prohibited Indigenous peoples from seeking legal representation, including self-representation. This clearly demonstrates that the legal system was not intended to be equally beneficial for all. On this slide, I feature Sir John A. Macdonald, the first Prime Minister of Canada. Macdonald is a highly controversial historical figure who drove the quote-unquote creation of Canada, despite the incredible harm inflicted upon Indigenous individuals, communities, and traditional territories. Interestingly, as a lawyer, I see Macdonald signifying the complex way that the Canadian legal system is implicated in the contemporary disadvantage of Indigenous peoples. Yet, the contemporary increase in Indigenous lawyers tells us that the legal system is also regarded as a concrete area for societal change. That said, let's turn to the admirable work of a few passionate Indigenous Canadian lawyers who fiercely advocate for Indigenous rights in Canada. Meet Krista Big Canoe. She is Anishinaabe from Georgina Island First Nation in Ontario. She is best known for her position as the Legal Advocacy Director of Aboriginal Legal Services of Toronto, and is particularly passionate about Indigenous women and children's rights. Meet Donald Worm. He is Cree from Kawakatoose First Nation in Saskatchewan. He is best known for advocating for Indigenous Canadians in contact with the criminal justice system. Interestingly, he was on the Commission Council of the Ipperwash Inquiry, which investigated the events of the infamous Ipperwash crisis. Meet Catherine Hensel. She is from the Secwepemc Nation in British Columbia. She is best known for advocating for missing and murdered Indigenous women and girls, and is celebrated for her strong media presence. Hensel also sat in on the Ipperwash Inquiry. Meet Caleb Ben. As a member of the Dene Nation in British Columbia, he is best known for advocating for the protection of traditional Dene territory. Ben is truly inspirational, as he began this advocacy work before he was a licensed barrister. Meet Jean Tillett. She is Métis from Ontario, which led her to become the founding president of the Métis Nation Lawyers Association. She is best known for specializing in Aboriginal rights law, which, as we now know, is distinct from Indigenous law. Now, I would like to refocus the discussion on the legal system as a macro structure. Despite the incredible advocacy work that these contemporary Indigenous Canadian lawyers are engaging in, I would like to ask, are there subtle implications for conforming to the current structures? It's important to emphasize that the Canadian legal system only marginally values traditional forms of indigeneity. This recognition can be seen through the legislated responsibility to offer court translating services, for example. As a 2018 report identifies, the Translation Bureau received 750 Indigenous language requests in the period from 2017 to 2018. The legal system has also adopted what is called the Gladue principle, in response to the 1999 Supreme Court of Canada decision made in R v Gladue. Now, precedence has been set, and when sentencing, courts are required to consider the particular colonialist conditions related to an Indigenous individual's criminal conduct. Finally, Correctional Services of Canada has adopted healing lodges, such as Okima Ochi, which was founded in 1995, in order to provide more relevant treatment for Indigenous offenders, an alternate to more punitive and restrictive forms of incarceration. I'd like to recognize that this criticism is not to delegitimize the positive impact that these Indigenous-informed legal system revisions have had on those in contact with the system. Rather, I want to highlight these factors in an attempt to suggest these revisions may be mere band-aid fixes to a greater structural problem that does not regard indigeneity as worthy of equal attention. Ultimately, by conforming to our legal systems, are these featured Indigenous lawyers fueling the myth that, now, Canadian legal system structural reform is impossible? I would like to meet this question with the assertion that legal system structural reform is possible. To explore this potential, we can look to the aims of Indigenous settler reconciliation and the benefit of Indigenous self-governance. The Truth and Reconciliation Commission makes a powerful statement that the preservation, revitalization, and strengthening of Aboriginal cultures is best managed by Aboriginal people and communities. This assertion demonstrates that if the Canadian government, and subsequently the Canadian legal system, is genuinely committed to reconciliation, we must value Indigenous legal traditions as of equal import. Further, it asserts that Indigenous peoples are fully capable of, and even better off by, self-management. This fundamental truth can be realized through the process of Indigenous self-governance. First, it is important to note that, through a 1995 agreement, the federal government recognized that Indigenous peoples have an inherent right to self-governance. This should coincide with the belief that, as established societies, Indigenous peoples have and currently have a sophisticated way of informing and regulating community behavior. Further, true equal democratic treatment requires that each citizen have a say in who governs and represents them. I believe it's worth recognizing that, as Bob Joseph says, while self-government is not a quick fix for the deeply rooted social, health, and economic issues that plague Indigenous communities, it is a step towards empowering communities to rebuild and heal. That said, the potential for Indigenous self-governance is powerful because it coincides with the promise of the implementation of particular legal structures that are relevant for each diverse community. In sum, until Canada does away with our current paternalistic attitude towards Indigenous peoples, let's commend these fierce advocates. These individuals all value the importance of taking advantage of their access to education to bring awareness to and defend the rights of Indigenous peoples in Canada. Though they do not strive to actually dismantle the system, they reflect and embody the long-standing legal struggles of many Indigenous Canadians, which began to rise in the 1970s. Ultimately, these lawyers are all working to recognize the rights of Indigenous Canadians, which significantly contributes towards widespread public awareness of and support for implementing Indigenous self-governance. Despite the inherent issues with the greater structure of Canada's legal system, these lawyers deserve recognition and immense appreciation. Now that you have hopefully learned a bit about the biases embedded in and subsequent implications of our Canadian legal system on a macro-structural scale, I urge you to reflect on what you can do, as an individual who actively sought out legal education, to combat these challenges in order to contribute to a systemic shift that values all members of the Canadian population equally. Thank you for listening, and I look forward to hearing any and all thoughts, comments, or concerns. Further, I look forward to hearing the presentations that all of you have been working on throughout this semester.